All right, welcome everybody. We've got a great turnout here for this event. My name is Todd Hefner, and I'm currently the treasurer of the Georgia Bar Association Construction Section and a construction associate with Troutman Pepper. I'm going to try and do as little talking as possible during the next hour and a half, and that's because we're really excited to welcome 5 incredible construction arbitrators from across the country who have graciously agreed to join us today. If I were to list our panelists' many accomplishments and accolades, we would hardly have any time for what we are all here for. So I'm going to be keeping the introductions as brief as possible. Going in alphabetical order, Albie Bates is a partner with Troutman Pepper and hails from Pittsburgh, where he spent his entire legal career focused on the construction industry. In addition to his work on behalf of clients, Albie has served as an arbitrator or mediator in over 150 disputes. Next is Jenny Fletcher, who is senior counsel with Evershed Sutherland here in Atlanta. Jenny has spent her entire career focused on the construction industry, and in addition to her work on behalf of her clients, has served as an arbitrator for over 25 years. Up next is Doug Oles, who is a senior partner with Oles Morrison in Seattle, Washington. While continuing as a senior partner at his law firm, which is concentrated in construction since the 1930s, he has mediated and arbitrated dozens of disputes, mostly in the Western United States. We also have Roger Peters, who now exclusively serves as an arbitrator, mediator, and dispute review board member, which he has done for the past 10+ years, making his home near Tampa, Florida. Previously, Roger served as executive VP and general counsel for Dick Corporation, now known as DCK Worldwide, in Pittsburgh for approximately 35 years. Finally, and certainly not last but least, Wendy Vanoit is a partner with Cozen O'Connor in Boston. Wendy has devoted her career to the construction industry, and when not working on behalf of clients, she regularly serves as an arbitrator and sits on several distinguished panels of neutrals, including for the AAA, ICDR, AAA Mega Projects Panel, and CPR. Thank you all for joining us. I think I speak for all of the attendees when I say we're excited to have you. And despite this being a construction arbitration themed event, I'd actually like to start us off with the recent amendments to AAA's commercial rules, which became effective on September 1st. In your CLE materials, which I think you might be receiving by email right now, you should have a copy of AAA's summary of the changes. The changes include the addition of a joinder and consolidation rule, explicitly allowing for virtual hearings, and a lot of other updates and changes. So the first question I'll pose to our panelists is this: is there anything in the updates that stood out to you, either bad or good? And Wendy, I'll ask that you go first.
Well, certainly with all of our collective experience with electronic arbitrations and mediations, et cetera, in the last few years, it's nice to see something more explicit in the rules about that. Because I have experienced as an arbitrator disputes amongst parties as to whether or not the virtual hearing really affords them the same rights and remedies that they would have gotten in an in-person hearing. And we could debate that to the end of time, but it's nice seeing something more explicit about the arbitrator's discretion to do that. Obviously, you mentioned the consolidation and joinder rule, which is Rule 8 here in the commercial rules, just to make sure it's really confusing and everybody will reference it wrong because, of course, it is Rule 7 elsewhere. So, you know, that's neither here nor there. I'm not sure why the AAA did that. What else? You know, I like seeing in the emergency measures of protection a cost allocation scheme, which didn't exist previously because I've had some personal experience with that as well. So, and of course, confidentiality, that comes up quite a bit. And there is now an explicit provision requiring confidentiality. So that's also nice to see. So let others comment on what stood out to them. Anyone?
There was nothing really specific.
I'm sorry, Albie, go ahead.
I was going to say there was nothing really specifically that jumped out to me. I think a lot of the rules are similar to what was done in the most recent amendments to the construction rules. So there's a little bit more of a unification between the construction and commercial rules that might otherwise have existed, and some updates even from the international rules, particularly the emergency measures. provisions. So, all in, I thought it was a great set of changes, and give the AAA kudos for all the hard work in putting together the latest revisions to the rules.
I likewise noticed the confusion between Rule 7 under the construction rules and Rule 8 in the new commercial rules. But I think that the enhancements to the consolidation and joinder provisions, and particularly arbitrator authority over not just that, but dealing with arbitrators, because one of the complex aspects of combinations in arbitration is if you end up joining two arbitrations where you have each has a panel already in place, how is that going to be dealt with? And of course, the parties have their objections that they didn't participate in in the particular panel that they're now ending up with. So I thought that was good. And the big takeaway for the audience probably is the AAA's continued effort to give arbitrators authority and discretion so that there is no chance of their actions being overturned.
Everybody should also be aware that the ICDR also amended its rules this year. So those are out there, similar set of, high level changes to what Todd circulated to everyone. So just be aware that they're there, and there are some changes to the ICDR rules as well.
All right. Well, so I'll jump kind of to the next topic then. And for the remainder of our time together, I plan to kind of walk through the various phases of an arbitration and generally focus my questions on what constitutes effective advocacy at each stage. But obviously we can take this in any direction our panelists prefer. And I'm going to try and leave plenty of time for audience Q&A at the end. I'm sure they have some of their own questions. But before I get to my next question, I just want to highlight one of the parts of the CLE materials. It's slightly outdated, but it's a survey that the ABA Construction Forum did that I had a copy of from 2015, where they polled over 200 construction arbitrators. And the first question I'm going to ask our panelists stems in part from question 5A in that survey. And it kind of relates in my mind to arbitrator selection. So there are multiple ways you can be selected to serve as an arbitrator, either party selected, appointed by two party selected arbitrators to serve as the chair, or chosen as part of a rank and strike process, seeming to be the three most common. And a simplified view of the survey results effectively indicate that 2/3 of party appointed arbitrators act in a neutral manner based on the 200 arbitrators polled, meaning that 1/3 of party appointed arbitrators are going to advocate on behalf of who appointed them. So with all of that said, I want to know, how does the manner of selection influence your approach to the case, if at all? And Doug or Roger, I'll let one of you start.
Doug, why don't you go first?
Well, first of all, as Wendy said, this virtual format that we have here, it has pluses and minuses. And one of them is we can't just ask people to raise their hands and see how many of you are litigants in arbitration or how many of you are arbitrators. So we have to sort of address our comments to a blind assumption about that, or maybe just looking at the list of attendees. So welcome to everybody that's here. I think that ethically, the way that arbitrators view things, we are supposed to really act as neutrals, and that's how I feel more comfortable acting, regardless of whether I'm appointed by a party or not by a party. And I think there's, because if you're going to have arbitrators acting as advocates for the parties who appointed them, then why even have three arbitrators? Why not just have one arbitrator who's neutral and save all the money and the cost of a three arbitrator panel? So I mean, that for me, I have a tendency to try to look at everything as a neutral. If outside the United States, it's a different approach. For example, in Germany and some other places, it's understood that that it's okay for arbitrators to be advocates in certain contexts, because they're providing expertise to help the neutral member of the panel understand things maybe that weren't fully clarified by the testimony. So maybe it depends a little bit about what your background is, but I think if you are writing a contract and you're trying to decide how you're going to select arbitration panel, or if you're going to have three as opposed to one, this is an important consideration, and you may as well just write it in. Even if you have party appointed arbitrators, you can still specify that they're going to serve as neutrals, and that's my preference.
I totally agree with Doug. Probably more than half my appointments to arbitration panels, I am party appointed. And however, I explicitly tell the party that's appointed me that I'm going to serve as a neutral. And I take that very, very seriously. I've had one occasion where I was party appointed in an ad hoc arbitration, and I was told that it was going to be a neutral process, and then found out that the other side's party appointed arbitrator absolutely refused, and that he was going to be an advocate. And that became a big dilemma in that ad hoc arbitration until the chair was appointed. And the chair was extremely surprised that that other side's party appointed was going to act as an advocate. And he tried strenuously to get that particular arbitrator to come around to being a neutral. And he absolutely refused. The good news is that case settled and we never had a hearing. But that was not going to be a pleasant experience, I can assure you. So I don't think any of the selection methods really impact me at all. I always want to serve in a completely neutral capacity.
I would just add that most of the arbitration rules default to arbitrator neutrality, irrespective of how the arbitrators are selected, the most notable exception being insurance-related arbitrations, and we'll set that aside. But almost all of the rule sets explicitly state that the arbitrators will be neutrals. And in my experience, that's how they act. Even it doesn't, at least domestically, it doesn't matter who appoints them, they're going to act as neutrals, particularly if they're AAA trained, et cetera. You know, that's somewhat ingrained in us, I think, as a result of our training.
Albie or Jenny, any bad experiences with another party appointed arbitrator?
I can't think of any bad experiences, but Todd, you mentioned originally that this survey is a bit old, and I think reflected in the other panelists' comments is the idea that this is something, at least in domestic arbitration, that has changed over time. And I'm going to probably show my age more than once in this discussion. But, you know, back in the day, AAA arbitration, if it was a party appointed situation, which was very unusual in AAA arbitration 25 years ago, we used to call it yours, mine, and ours. And that would automatically mean that the arbitrators appointed by the parties could be advocates. That is absolutely not the case anymore. And as Doug mentioned, it was never the case in international, well, you mentioned Germany, which is a whole different breed of cat, I guess. But in the ICC world, it's always understood that you will be 3 neutrals. And as Wendy points out, I think that's absolutely the case in domestic arbitration now. But practice pointer to everybody who's out there whom we can't see, but Doug has welcomed and I also welcome. This is something that you need to be confirmed. Don't leave it to guesswork. When I am a party appointed arbitrator and someone else is also, and we pick a third, we agree right off the bat, okay, what we're going to do is have no further ex parte communications with our appointing person after we get the panel constituted, and we will all be serving as true neutrals. And you don't want to get in the situation Roger was describing where somebody's refusing to act that way. You need to be sure that the parties participate and the arbitrators all understand what page they're on.
I'm frankly very surprised by the survey result that you cited, Todd, at 5A. Where,
I think old news.
It's old news, but I mean, roughly half of the people answering that survey, or nearly half, said that half the time or seldom did they find the neutral to be neutral in their behavior and decisions, which is completely contrary to my experience, certainly. You know, I'm often one of the people that are selected, or I'm selected by the other 2 parties as the chair. And at some points, you're not even sure who it was that appointed one or the other of the arbitrators, because it really, at the end of the day, doesn't matter. We're all serving as neutrals. We're all trying to get to the right result. And you don't see that bias coming into the decision-making process.
Okay. Well, it's great to hear, honestly, that all of you approach it the way you do. And maybe it's the esteem of this panel has not had to deal with it too much. That it's a different class of arbitrator that proceeds in that manner. The next topic I wanted to touch on is pleadings. I mean, we all know that an arbitration can be commenced with the simple filing of a 2-page form, and that therefore leaves the parties a lot of flexibility in how they present their claims and allegations. And so I wanted to ask, what are some of the most and least effective ways you've seen parties present their claims? So Albie, I'll go right back to you for this one.
I guess it depends in part upon the size of the case. If we're dealing with the larger cases, which I think the folks on this panel certainly deal with, you expect to see some detail about what the case is about at the time of the filing. You don't expect to see a complaint style pleading, but at least some description. It's a couple of pages long. It gives the arbitrator sufficient amount of information about the case when they're looking at it, when they're trying to make disclosures, when they're planning for the preliminary hearing conference, that they have some understanding of what the case is about at that point. So it's, I guess that's the answer, Todd. It's not robust like you would see in a federal court or, some of the state courts where the pleading isn't even notice pleading, but something that gives you a little bit of the story, gives you a flavor of what the dispute is about, but, doesn't go the extreme, because you're going to have further statements filed that are going to tell you exactly what the case is about, what the precise quantification of damages is, and all of those sorts of things. So that's my general thought.
Anyone else have any strong feelings, Jenny?
Yeah, I mean, the most, and Albie touched on this going forward in the proceedings, the most important thing from my perspective is a very detailed itemization of damages. And if that doesn't happen in the actual demand and response, which it often doesn't because people are rushing to get their things filed, but very early in the process, you need some kind of pleading, and it may or may not be an actual pleading, but a statement of claim, detailed statement that shows you what each side is claiming. I always have people ask me, do you represent the plaintiff or the defendant? And I always say, you don't understand. In my cases, everybody sues everybody. So probably you're going to have damages claims from each side against each other. And it's really important to understand that. It's also interesting from an arbitrator's perspective to see if that changes over time. So I think that really that to me is the most important thing that needs to be in writing in the file fairly early.
Yeah. My standard procedural order that I always issue to the parties at the front end of the case requires a detailed statement of claim, as well as a detailed statement of defenses. And I want that early on so that A, they know what's being claimed against each other, but also to guide the degree of discovery that might be necessary in the case. So I personally believe that it's extremely important to get that detailed statement of claims and defenses out early and not allow any party to hide the ball, until later in the case.
Like Albie, I would much prefer to have a detailed, almost complaint-like filing for the demand for arbitration, and maybe even an answer from the respondent. But I'd say more than 50% of my arbitration cases are really just the 2-page document filed with the AAA, and it gives you very little information. But then we do what Wendy prescribes, which is, let's have a detailed statement of claim. We set that forth in our procedural order, case management order, early on, so that everybody's on the same page. But I just got appointed to an ICC case, and the complaint was 45 pages long. I had an answer and a counterclaim that was 45 pages long, and had a reply that was 30 pages long. So I am up to speed. We haven't even had a meeting of the arbitrators yet, of the tribunal. So, but that was very, very helpful to understand that. And there's a very detailed statement of damages in both cases. So that's, I totally concur with Jenny that damages are critical in these arbitration cases, and sometimes the participants don't pay enough attention to that up front.
Plus, if you want to look at it that way, we're part of a larger dispute resolution process that usually in construction cases involves a mediation. So one way of setting parties up so that they'll be prepared to mediate in addition to pursuing the arbitration is to make sure that they've exchanged their claims and defenses in a reasonably full manner early in the case. The other thing that maybe isn't narrowly part of the complaint, but that happens at the same time, is the disclosure of witnesses and expert witnesses. And our industry is not that big. So there tends to be a lot of, I see a lot of cases where the same some of the same experts or, even some of the same witnesses turn up again in multi-party cases. So you want to make sure that you get a full disclosure of not only fact witnesses, but also expert witnesses early on, in case there's any kind of a conflict that needs to be disclosed by members of the panel.
Okay. I want to turn then to kind of like the phase of the case that I've lumped together, the preliminary conference and scheduling order, all those kind of preliminaries besides the pleadings. And I can tell you, I've been in rooms where parties say to themselves, I'm before our arbitrators, I want to start teaching them about our case and our positions. And is this a good idea at this early stage, or put differently, how much advocacy is going to be a problem in these procedural matters at the front of the case? Jenny, I'll start with you this time.
Sure. I think as a general proposition, arbitrators don't like theatrics. It's not a jury situation. You don't need our attention. We're here because we have a special expertise. As Albie said, all of us in this panel are on the mega case panel for AAA, and we do construction industry matters where, it's about money, folks. I mean, that's what it's about. And we're not likely to be swayed by the fraud arguments and the general theatrics. I do think it's helpful for the parties to bring to the forefront what the case is about. I think it is helpful to come forward with a bit of an explanation around the case and what it's about and what the arguments are. But I see dramatic, and I have had cases recently where the arguments are very dramatic, going back and forth and mudslinging and briefs that are way longer than they need to be. And I just don't need that. That isn't what is going to allow me to decide the case fairly.
So at the preliminary hearing, Todd, I guess I would say that in advance of the preliminary hearing, I generally will send out an agenda. And it will cover the 20 things, 25 things that are going to end up being in case management order 1, along with a request that the party, maybe more than a request, that the parties meet and confer with one another in advance of the preliminary hearing and work out as many of those things as they can and provide, sort of a summary of what they've been able to agree upon in a joint report, and then things that they haven't been able to agree upon, list. We weren't able to agree upon the number of depositions, how we're going to handle ESI, what these things are, what your respective positions are, so that then the arbitrators have those in advance of getting together at the preliminary hearing. You'll need to know enough about the case, obviously, to make intelligent decisions and help them scope what the discovery is going to look like in these larger cases. But it's a very helpful way of getting everybody on the same page in advance of that preliminary hearing, without a lot of, as Jenny says, the theatrics that sometimes go along. I think you want to have an opportunity for each side to present briefly what the case is about, so you understand where they are, with things like, do they have a fully itemized statement of damages yet? When are they going to do that if they don't have it done, and why is it not done yet? And understand what's going on in the case, what needs to be done in order to present, and how long it's going to take to get from where we are now until we get to the hearing. Do they have a mediation scheduled at some point along the way? All of the things that end up being part of case management order 1. So it's, I don't know, a long-winded answer, but those are the kinds of things I like hearing the parties discuss in advance. And then once we get to that preliminary hearing conference, which really sets the stage for, when the hearings are going to be and works back. And I think most of us on the call, I don't know, others may have different views, but once those hearing dates get set, they're pretty sacrosanct, and trying to keep those things set in stone. And one of our jobs as the arbitrators is really to manage keeping those dates, so that if disputes arise, you deal with those as they come up, so that you don't lose the dates. Because as soon as you start losing the dates, you've lost some of the benefit of us going into the arbitration process. It's really important to try to hold the dates once you set them.
I follow the same procedure that Albie does. I send out my draft procedural order in advance of that first conference, which I like to do by Zoom or in person ideally, but more recently by Zoom. And I also like to tee up kind of my views on some of the big picture items. For example, under the depositions section, I'm like, if you want to do depositions, you better tell me why, right? I don't let them assume that they're going to be allowed that opportunity, because of course the construction rules don't afford the right to depositions as a matter of right. So, I like to tee up some of those issues and kind of send a message to the parties about what they're going to need to prove in order to be able to take more robust discovery than would be afforded by the standard rules. And I hope you all have read the new AAA construction discovery guidelines, because they're wonderful, not just because I worked on them, but because they provide input from a whole host of industry participants who were polled. I was personally involved in that, and they're really quite good. But in any event, I try to push the parties in kind of into a streamlined process, and so that they don't simply run amok. I also, for example, express my preference for a chess clock. I happen to like the chess clock in order to control the length of the proceedings and really force people to be prudent and efficient at the hearing. So like, I always write that in, and I say, subject to discussion, of course, but strongly recommended. So that's my personal process.
So in regard to the preliminary scheduling conferences that I've chaired and participated in, I'm like Jenny. I don't need any theatrics, but I do want to hear what their position is. And so many times counsel will say, well, the other side may disagree, but this is how I see the case and the particular issue at hand. And then the other side will do the same thing. And so they advocate their position, but it's not theatrical.
Doug,
Yeah, this is one of the critical things that happens in a case, is that initial case management order number one. I should begin by probably apologizing for the weird light in my screen, but out here on the West Coast, the sun is just coming up, and people are in Seattle, they're bowing down and worshiping it in the street. And if I move to the center of the screen, I will be wiped out by this blinding radiation. But the thing I was going to point out is that I think all of us follow this policy of mailing out or sending out a standard kind of a draft order for people to review in advance, and that's a great practice. But what I wanted to emphasize is that they are different. It's not like there's some mass industry agreement as to what should be in those orders. They do vary from one neutral to another. For example, I've noticed that out in my part of the country on the West Coast, having specifying that there's going to be a transcript and a court reporter is less than half the time. It's not the normal practice. But when I'm on the East Coast, it seems like you all it's much more common that you have a transcript. So that would be an example of a difference. Some neutrals will also limit depositions in terms of a number per side. I've always kind of preferred limiting them in terms of hours per side, so that you reward brevity and preparation between the parties. But anyway, that's again something that it's going to depend on the neutral and maybe on the form. So when you get these forms, those of you who are litigating or just beginning to get into arbitration, look at them carefully and don't assume that it's going to be just like the one that you saw the last time you did an arbitration, because that may not be true.
The other thing to emphasize is what everybody has really said, but Albie started it, I think, the importance of requiring the parties and their counsel to confer before the preliminary conference. Because one of the things, I'm with Wendy all the way on depositions and limited depositions in arbitration, but sometimes parties will see it differently and they will reach an agreement on something like that. And I think most of the time, somebody jump in if you say that I'm wrong about this, but most of the time an arbitrator or a panel will go along with the parties' agreement. If the parties have stipulated to something, it's their process. And if they want 10 depositions each, well, I think it's excessive, but go for it. And sometimes I'll do it in stages. I'll say, okay, let's start. You want 10, let's start with 5 and see where it goes from there. And very rarely do they go the whole gamut. But I think, again, the importance of conferring is is huge, because that's where you can come up with an agreement that an arbitrator might not rule for.
All right. Want to turn to discovery. Some people were kind of already hinting at their views on it as part of their last answer. But it seems to be the growing trend that in construction arbitration, the discovery costs are not that different from federal court, or at least that can often be the case. So kind of a two-part question. Do you agree that that is often happening in construction arbitrations? And two, how do you view your role in managing discovery in an arbitration? Doug, do you want to start with that one?
Yeah, sure. I mean, you hear that complaint a lot, that arbitration is just as slow and expensive as court. It shouldn't be, and I think often it isn't, but it can be. So that's a very vacillating sort of answer. It can be sometimes when people write contracts, they specify that disputes will be subject to arbitration, but that the arbitration will be subject to the normal civil rules, which to me makes no sense, but it happens a lot. I just arbitrated a case that was like that, where it was subject to even the state evidentiary rules. So I was in arbitration, excluding exhibits and ruling on things like the best evidence rule, which is sort of unusual in arbitrations. But so it can be, but the beauty of arbitration is that if you let it do what it's designed for, then it should be much more efficient and much faster. And of course, especially over the last 2 years, with all the courts shutting down during COVID, arbitration continued merrily on via Zoom and turned out to be much faster than court proceedings, many of which are still lingering on from cases that were filed 2 years ago. But there does need to be, some serious thought given. If you don't force the arbitrator to follow the court rules, then the arbitrators are going to tend to restrict depositions. They're going to tend to disallow interrogatories and requests for admission. And if they do that, then I think the pre-hearing discovery process in particular is going to be way faster and less expensive than court. So it can be, and it should be. It just depends if the parties who write the agreements allow the arbitrators to do their thing.
I'm mediating a matter currently on a very large project on the West Coast, and it's in litigation, and they have a hearing on Thursday with the judge to try and extend the commencement of the litigation hearings in the matter. And one of the bases for that, I was told yesterday, was that they still have 150 depositions to take between now and January. And I just almost threw up. I couldn't believe it. That doesn't happen in arbitration anymore. 25 years ago, it happened, because I had 3 of them that had 150 depositions. And I got so out of joint with those kinds of processes. I just think it's just complete waste of money and time. But, as Jenny said, if the parties want 10 aside or 5 aside, okay, that's fine. But so therefore, the litigation process, I think, is still more expensive than the arbitration process. Doug really hit the nail on the head about trying to limit interrogatories and requests for admissions. I think all that stuff is just really inappropriate in an arbitration. So those are my thoughts.
Yeah.
So let's talk about the elephant in the room, the proliferation of data, ESI.
That's the issue.
That's the expense of litigation. I mean, we can limit depositions all we want. We can not have interrogatories. We can require affirmative statements of claim. But the biggest expense that parties are still going to incur has to do with exchange of data and all of the electronic data. And that's something that arbitrators need to be up to speed on and able to organize for them. I mean, that is, we're now at the point in arbitration, and I'm sure you have it, Wendy, in your standard order, and I have it in mind, we all do, about identification of data custodians and how many each party can have. And there's a lot of regulation around that. So that's just an expense that's very hard to manage in litigation or arbitration. And it's important that arbitrators take some control of that process.
That's the big one. I agree with you completely, Jenny. That's where the time and money gets spent. And I think most of us will ask the parties to put together a ESI protocol. So they're coming back and saying, this is exactly what we're going to do. They've spent a lot of time going through it. I think sometimes you see arbitrators that don't really dig in and try to review exactly what it is that the parties have agreed to in the ESI protocol. They're more concerned, it's going to take this much time, but they're not going to get into the detail. And I'm not suggesting you go in and talk to them necessarily about the way in which they're going to produce documents and whether it's going to be native or TIFF or how they're going to handle this, that, or the other thing. But from a global standpoint, how much information is really going to be produced and what part of that is really material to the issues in the case, and how do they find those documents and produce them so that everybody's getting a full and fair hearing, but you're not wasting a lot of time and money on the exchange, looking for that one smoking gun that's at the bottom of a haystack somewhere. And that's the key. That's the difficult part.
Yeah, one of the kind of keys within the new AAA guidelines is the proportionality concept, which, by the way, exists in the federal rules now too, but has existed on the international front for a very long time. So proportionality to the amount of dispute, the complexity of the issues, of course, that should always be part of the metric as to how much discovery should be allotted. I tend to delve pretty deeply into ESI issues because that is the area where I, as an arbitrator, see the most disputes. And so I think it's very important to really focus on that at the front end, absolutely invite them to prepare an ESI protocol, but then the arbitrators have to review it. Yes, absolutely, it's the party's process, but within reason, right? And so I tend to take a bit more muscular approach, but also because I know a lot about ESI, I tend to really delve deep into those issues and even make suggestions to the parties on how they can streamline it, focus it. I'm in favor of also the forced red fern schedule, which some of you are probably now accustomed to, which is kind of a tabular form of document request, which requires the parties to not only identify what documents they're asking for with reasonable particularity, but also a statement of why it's relevant to the issues in the case. I love that because it forces them to actually think about what they're asking for and why they're asking for it. So it defeats that customary process of give me every and all project document, right? You can't do that. You have to be far more particularized and identify specific categories of documents and really think about why you're asking for them. So I'm in favor of all those things in order to streamline the process, keep the cost down.
Technology has grown so rapidly in this field. It's amazing what people can do in short periods of time with that technology. I was involved in a case recently in which a non-party engineer had 5 different projects on his computer, and they were refusing to produce any emails because they were afraid of contamination and exposure of his emails on these other projects. And one of the participants in the arbitration, one of the counsel who was very familiar with the technology, said, we have a way to exclude all those other projects by doing ABC. And immediately the panelists took that to heart and said, okay, if you can do that, we'll allow the production of this guy's computer. And lo and behold, in 3 or 4 days, all that information was provided. So it's amazing what has transpired in the last 10 years.
I think at a philosophical level, we need to rethink the concept of relevance, because over the years under court rules, relevance was expanded to being, anything that had even the most tangential connection with some potential claim or defense that was alleged in a case, and it took the lawyers off into the last box in this last storage archive of a party. But in construction cases in particular, which are multi-party, and in which there are very often some players who have a lot more money than the other players and can use discovery as a tool to oppress the ones that have less in the way of assets. I think we need to remember that one of the things that arbitration can offer to parties is the assistance of the skill and the experience of the arbitrator in guiding them so as to narrow the scope of relevance to what's really important in the case. And it's hard, I think, for for all of us who have a background in court litigation, where you know that there's just this unlimited definition of relevance, but that doesn't really work with the kind of masses of data that we have to deal with now. So I think it's actually a kind of a cutting edge issue, which is being resolved arbitrator by arbitrator across the country. And I know, as Wendy knows, who's a very distinguished international arbitrator, is in some of these, the international cases have known this for a long time. They have placed a much tighter restriction on relevance than US courts have. And I think maybe we can learn something from those as we move forward.
That's one of the things, I mean, as we're sitting here and we're talking about this, that came to mind is, when you look at the international regime in terms of the way evidence is presented, they're using the witness statements, right? So a lot of information is being exchanged at a very early point in time. It makes it much simpler and more direct to say, I need these documents because they relate to contention in paragraph 27 of this person's witness statement, and they're directly relevant because. And I think that's, Doug, I agree with you. That's, using a Redfern schedule, using witness statements, using, if you're doing the American style, a very detailed statement of claim and very detailed statement of counterclaim and statements of defenses, to get that information out there so that, early in the case, each party understands what the case is about, so they can begin to then focus on the real issues in dispute and not all project documents or very broad requests.
Okay. We know discovery disputes are somewhat inevitable. Beyond requiring parties to have a meet and confer obligation before they bring any disputes to you, what do you find are the types of relief you find yourself granting when a party asks for it, and what kind of discovery disputes are kind of a waste of your time when brought to your doorstep? Wendy, I'll start with you on this one.
ESI disputes, of course. I see a lot of disputes over number of custodians and then people playing games with search terms. That's always extremely frustrating, where the parties agree on, 30 search terms each, but then somebody comes up, designates the word the, or something. I'm joking a bit here, but something that is just so broad that it's going to hit on every document in the universe, and so I'll be asked to get involved in that. And I've had that happen to me as an advocate as well. So this isn't limited to my experience as an arbitrator. So, arbitrators don't like to get involved in those types of disputes. We really, really, really wish the parties would work that out and not bring that to us, because if we have to get involved, we're probably not happy about it. We will, but they may be more unhappy with the result at the end of the day. So, and I also see a lot of disputes over depositions, but that's usually over the number of depositions, who's going to be deposed, et cetera. And again, I think I previously shared my views on that. I like it when people start with if I'm going to allow depositions at all, start with a 30b6 and then come back and tell me, do you actually need more than that or not? And I definitely don't want to hear that, oh, gee, I need to know what everybody's going to say before they're going to say it on the witness stand. That is not a legitimate reason to depose somebody in my world. If the argument is, oh, I legitimately do not understand the claims being asserted against me or the defenses, I said, is that not resolved by the detailed statement of claims and defenses that we designated in the procedural order? Can it not be handled in that fashion? If it truly cannot be, okay, let's talk about some limited depositions. But again, I hate dealing with discovery disputes and wish they could all be resolved as between the parties. But I do stress to the parties, we're there as arbitrators to help you when you need it. And I would prefer for them to bring things, if they can't resolve it, bring it to us sooner rather than later, so it doesn't derail the arbitration hearing dates. That's, I think, very important. I often see advocates wait until very late in the process to bring these issues to the arbitrators. And then all of a sudden it's, oh no, the hearing dates are in jeopardy. And, is it, why didn't you bring this to us 6 months ago when we could have dealt with it then? Because most of these things percolate for ages, right? And so, that's another thing that I try to stress with parties is if you have an issue that you cannot resolve, please bring it to us sooner rather than later so we can do our jobs and be helpful to you.
I recently had an issue in an arbitration matter concerning the production of documents from a non-testifying expert. And obviously in this case, the claimant wanted that information. And we had to look under the applicable law of the that was stated in the contract to figure out whether or not that non-testifying expert had to produce his reports. And so I thought that was a pretty interesting scenario, and the particular jurisdiction said they did not have to do that. So I thought that was an interesting one. But I've experienced a lot what Wendy has told us about. ESI is a constant thing. And the other thing that really I particularly don't like is that people don't live up to the timeframes for exchange of documents. They probably more than 50% of the time, they're not complying with those dates, and they don't bring it to us until it's 3 or 4 months later. And they're saying, well, the ABC hasn't given us these sets of documents, and so we want to push the hearing, and then we just shake our heads. So that's not going to happen. So, but those are my thoughts.
And the other thing I would offer as a practice pointer for parties to think about whether they want the chair to make those decisions or whether they want all 3 arbitrators to make the decisions on non-dispositive motions. It's often raised in the preliminary hearing conference, but be sure to think through that decision. From a timing standpoint, it's much quicker and more efficient if there's only one person that you're trying to schedule and get in front of to get those decisions made. But many parties like the comfort of having 3 people be involved in that decision. No right or wrong. You just need to think through that carefully at the early stages of the hearing and make a decision. Sorry, Doug, I didn't mean to cut you off there.
Oh, no, not at all. That's an excellent point that you made. I was just going to mention something that I get a lot of, and I just spent a month arbitrating a case where unfortunately I did not have any other arbitrators, so I had to rule on all the motions myself. And I had like 12 or 13 pre-hearing motions. And one of the big themes was motions in limine with regard to scope of testimony. And I think it's something else that parties should think about, whether it makes sense to do that. One thing is anybody that's been practicing for a while knows that there are a lot of expert witnesses who like to sort of assume the role of being the advocate for their client's position, where they don't just offer testimony on technical issues, the kinds of things that the arbitrator might not be familiar with, but they tell the whole story of the case. They tell you what the contract means and what the intent was. And so one kind of motion in limine that I see quite a bit is motions to limit the scope of experts to expert topics. And in the particular case that I had, I granted a number of those motions, which helped to get the case done in the time that was allowed. Another kind of motion in limine is to try to restrict tangential issues, because there's a tendency to go far afield sometimes in terms of saying, well, here's what the party may have says that they did in this job, but look what they did on some other job. And once you start litigating jobs that aren't even the one at issue in the case, you not only can add a lot of time and cost, but you can also have a lot of sort of distraction and a lot of oppression of the parties that have less money to play the game. And for example, in this case I just had, there was a motion in limine to exclude declarations that were filed in a divorce proceeding by the ex-wife of one of the parties, who in her declaration said that he was a lying, unreliable person. And so they wanted to put this in as, and not calling her as a witness and exposing her to cross-examination, but simply put in the declaration saying that he was dishonest. So I ruled on that one, but it had like 20 lawyers in the room. I said, has anybody else in this room been divorced? And if so, should I determine the credibility of your arguments by calling upon your former spouse and asking that person's opinion as to your credibility? And in the face of great silence, there turned out to be a support for the motion that I granted to exclude the evidence. But motions in limine, even though a lot of people think that they're worthless or unnecessary in arbitration because there's this idea that everything is admitted into evidence in arbitration. That is not necessarily true. And it is sometimes worth making those motions.
Oh, let's segue to another type of motion, dispositive motions. It seems that it's somewhat challenging to get dispositive motions granted in arbitration, and I think probably rightfully so. But what are some of the things that kind of have to be included or are more likely than not, or maybe not even more likely than not, but just stand a better chance to be granted when they come before you? Jenny, if you want to start.
So I actually love dispositive motions in arbitration. I like to make them and I like to review them. I think you're right that it's probably a little bit harder to get them granted because arbitrators, particularly in the preliminary stages of any kind of proceeding, are trying to be absolutely impartial and open to the arguments of both parties. But to me, the kind of thing that is a slam dunk dispositive motion that should be brought and that can turn the tide of an arbitration proceeding are things that are absolutely contractual and legal. Now, you don't often in arbitration have a statute of limitations defense or something like that, but very frequently you have waiver of consequential damages, no damages for delay or exculpatory provisions. And then the one that I see that I think is probably the most appropriate to bring is periodic waivers. You know, people who have waived the claims they're trying to assert in arbitration. And you may not win it as an advocate, you may not win it at an early stage, but that doesn't mean the issue goes away. Now, I am not a fan in court or in arbitration of bringing motions just to educate the panel. But I do think that if you've got something that you know is a slam dunk legal argument, flat out contractual or other legal bar, that's appropriate to bring, and you ride that horse all the way home.
Mm-hmm. Yeah, I'll add, I've actually granted summary judgment motions in arbitration as an arbitrator. They are few and far between, mind you, but they are very clear legal issues. Interestingly, the question I get asked most about by advocates is why an arbitrator didn't grant their summary judgment motion and then decided the exact same issue in their favor in the final award. And they said, why didn't the arbitrator grant it back then? And I said, would it have made the hearings any shorter? Would it really have made these proceedings more efficient? Would you have called fewer witnesses, et cetera, et cetera? And invariably they say, no. I said, that's why. Why should an arbitrator put their award in potential jeopardy if it's an issue that actually will not streamline the ultimate hearing? They are better off waiting and dealing with that issue in the final award, where it's unlikely to be challengeable. If they grant that dispositive motion earlier in the proceeding, there's a potential argument, I'm not saying it's a winner, there's a potential argument that the arbitrators did not allow the evidence to come in on that issue before making their ruling. So I will often, I'm often asked that question, and I truly believe, based on personal experience, that that's the answer, is that, and frankly, when parties bring requests to file a summary judgment motion to me, I actually say, okay, what's the motion? What's it about? Make some, initial judgments as to whether or not it's something that's going to be very factually intensive or not. And then I ask them straight up, is this going to shorten our live hearings in any way? Is this going to narrow the issues in dispute? Are we going to have fewer witnesses? And when they say no, then I'm less inclined to allow it. Because like Jenny, I don't want to be educated. You can educate me in your pre-hearing brief. I don't need to be pre-educated in a motion for summary judgment.
I'm a sole arbitrator in a large case on the West Coast in which a subcontractor is suing or was bringing a claim for all of its damages on this large project that is still ongoing. And the respondent objected on the basis that most of these claims were, quote, pass-through claims under its subcontract agreement and were to be presented to the owner rather than to the arbitrator. They were not ripe for arbitration. However, there were some claims in which the general contractor had settled with the owner and included all of the subcontractor costs for a particular phase of the project. And so I had to rule on what damages could be and what claims could be pursued in the arbitration versus what had to be passed through to the owner. And so that eliminated probably 2/3 of the claims of the subcontractor, because I ruled that the project was still ongoing and these were pass-through claims in which the general contractor had not excluded the subcontractor from recovery. But in one case he did, and therefore the subcontractor could bring the arbitration against the contractor for those claims. So that was helpful.
I'd offer two additional thoughts. The first one is, I think that there has been the perception that arbitrators are unwilling to grant motions for summary judgment. I think in the last 10 years, certainly in my experience, I've seen arbitrators more favorably inclined to consider motions for summary judgment in appropriate circumstances and to grant them. So I think I've seen that change over the course of my career, at least. The second, I really like the rule change that went in the last version of the AAA construction rules, where you essentially submit the mother may I letter requesting leave before you can file the motion for summary judgment. Because often if you submit a 2 or 3 page letter that lays out your position, the arbitrators can then confer and determine whether they believe you have a realistic chance at recovering or that relief being granted. So it saves a lot of the time and cost and the education processes, some of my colleagues have called it, of filing lengthy briefs. But if the arbitrators believe that it may be meritorious, then they'll allow the briefing to go forward, and it gives you a good indication that it's worth the time and money of submitting that motion.
Well, the speakers on this panel are mostly contract experts, and one of the things about contracts is that even if we see a clearly written clause in a contract which seems to suggest that summary judgment is appropriate, the laws of various states, various jurisdictions vary as to the amount of extrinsic evidence that may be admissible to try to prove that some specific language has been waived, or that it should be understood in the context of broader information about the project where it arose. And those things all make arbitrators pause before they're going to jump in and grant summary judgment, because if the non-moving party can identify any of these issues, like potential waiver or interpretation by the conduct of the parties, it's something that would tend to lead in a different direction from just a literal reading of the clause in a vacuum. Then those things, I think, are going to make the arbitrator reluctant to grant an early summary disposition of the issue.
I want to turn now to certain aspects of the final hearing, and then maybe some post-hearing briefing. What I find to be perhaps most inconsistent among arbitrators is their preferences for whether or not parties deliver live openings or closings, or reduce those to briefing. And I'm curious what your preferences are and how much your preferences may change based on the nature of the case. Doug, I'll go back to you if you want to start with that one.
Well, I think an opening brief is absolutely essential because, among other things, if somebody gets up and gives an opening statement and starts rattling off case citations, there's nothing the arbitrator can do about that. At the time, you really don't know what the case says, and you would like to be able to maybe, if there's some key case that somebody thinks is dispositive, you might like to be able to look at that before the hearing actually begins, which you can only do if there's been a brief in advance. So I'm a big fan of opening briefs. I'm less a fan of post-hearing briefs and of findings and conclusions and things like that, because I think what's happened, and Roger was mentioning ICC arbitrations. ICC arbitration got a very bad reputation over many years from having decisions and awards that were deferred by so many months that it was hard to honestly say that the arbitrators still had a fresh recollection of the demeanor of the witnesses that they might have heard half a year earlier. So I think it's very important that when a case is concluded, that you adopt a system that allows for a prompt decision while the testimony is still fresh in mind, because testimony matters. It's not just about documents. So I like opening statement is fine, and particularly if it's a complex technical issue, it's nice if somebody puts up some demonstrative exhibits that illustrate how the technology works. Over the years, I've been in a lot of cases where the technology that's at the center of the case is something completely new to me, something that I've never heard of before. I think many of us in construction have this experience over and over again. So for those purposes, it's good to have introductory materials that get you right there. But on the other hand, I think we need to be cautious about adding so many written submissions that you really extend the process, you make it way more expensive, and you end up postponing the award until after the thrust of the hearing has been forgotten.
I think it depends. Again, I was a sole arbitrator on a very complex bridge case with a very short time frame. The hearing and the award had to be rendered within 6 months of the date of the demand. And the parties took 2.5 months to find an arbitrator, which was me. And so they had 3.5 months to hold discovery and then have a 3-week hearing, and left me with 1 week to write it a reasoned award with findings of facts and conclusions of law. And so in that case, the briefing was essential to me to really understand the issues, and also helped me formulate a reasoned award at the end of the hearing. So in that case, it was very helpful. But typically, in most cases, I like pre-hearing briefs, short openings, not that last 3 or 4 hours. I want them to last maybe a half an hour or an hour. But again, as Doug pointed out, if there's a very complex case, and I've had several recently, it's very informative to have somebody explain the technology and the scientific issues involved more than just reading it on a page. And so I've found that to be very helpful.
In most of my recent, oh, sorry, go ahead.
Okay,
Go
I'll
ahead,
jump.
Jen.
Age before beauty. I agree with Roger, and I think that we need to remember that the beauty of the arbitration process and what makes it potentially a better mousetrap is that you do customize what works best for the case at hand. And I think that very rarely by the end of an arbitration hearing do I need a lot in the way of closing argument or closing brief. And if there are things that the arbitrators need to know about, they are in a position to specify, we need to hear more about this, we need to know the law on this issue, go forward with something that helps us on this particular issue. But in the beginning, I concur. An opening brief is helpful. I like opening statements, but I do think, and I think this is part of the materials that Todd sent around, creativity in the process is essential. To just follow the old rote mechanism of everybody calls a witness and cross-examines is not as effective as coming up with a way to really focus on the issues, and let the arbitrators help you with that. The arbitrators are in a position to tell you what they need.
I was just going to add, in my, I'm going to say the last 5+ years, I've seen most parties say either they don't want openings or they want 1 hour. But almost invariably we have pre-hearing briefs. My one rule as an arbitrator is please don't send me a 200-page pre-hearing brief. I don't like it. Please, keep it to the point. Give me the relevant facts, give me the relevant law. Don't write me a dissertation or war and peace that I have to read in advance of the hearing. So, that's one request. In terms of creative, what Jenny was just talking about, creative ideas on how to streamline post-hearing briefing. I've had arbitrators as well as offered to arbitrators to give them draft awards. They've actually asked the parties to submit draft awards as part of their post-hearing briefing, which is really interesting because it forces the advocates to write essentially a post-hearing brief in a very different way, something that the arbitrators can then pull from and dump into their final awards as well. So I like that, and I now regularly, when I'm an advocate, regularly offer that to arbitrators. I've also seen arbitrators actually outline how they want the parties to draft their post-hearing briefs. So where the chair actually provided an outline and said, both parties are required to draft post-hearing briefs that follow this outline. And that way the arbitrators can compare apples to apples, right? They don't have to go hunting for responses to arguments and figure out where in the parties' respective briefs to find an issue addressed. They can simply look at that outline, okay, issue number 1, and it's in the same place in both parties' post-hearing briefing. I thought that was super clever, and makes our jobs as arbitrators a whole lot easier as well.
If I can, my general practice is to expect to get pre-hearing briefs and allow opening arguments. But usually I use a chess clock, as Wendy had said earlier, so that if you, whatever time you take your opening statement, it's coming out of your chess clock time. With respect to the closing, my general practice is there won't be a summation at the end on the last Friday afternoon. That's not going to be a lot of help to anybody. But we'll sit down with the parties. The panel will talk first privately and then come back to the parties and talk about what we're going to do to close out the hearings. Do we need post-hearing briefs? Would we like a draft award? Would we want to hear about these specific 10 issues that we'll outline for the parties? Any of the things that everybody's talked about, but do that collaboratively with the parties, sort of in the last week or last few days of the hearing, after everybody's had time to sort of hear the evidence and formulate what would really be helpful to you to close out the case. And then you enter a short order at the end of the case outlining what's going to happen post-hearing, and you move from there.
Right. So I'm going to have one more question before I turn it over to audience questions. So if anyone in the audience wants to start using the chat feature to start queuing up some questions, they can do that. I'm going to duck after I ask this question, but the survey, it's question 23, basically says that arbitrators feel firmly that they never split the baby. But it is a constant perception in the industry that a lot of awards are of a split the baby variety. And I just want to hear everyone's reaction to that kind of old refrain.
One of the things that I have found that might lead somebody to think that you're splitting the baby is someone might have a claim for $20 million, but you only award them 7 or 8. And somebody says you're splitting the baby. Well, I'm not splitting the baby. The damages weren't any good for 20 million. They're only good for 7 or 8. Okay, but somebody might say, oh, you're splitting the baby. No, I'm not splitting the baby. It's basically my view of their damage entitlement presentations. And so I'm a firm believer that I have never split the baby.
And if you really want to eliminate that, write baseball arbitration into your arbitration agreement. That we have baseball rules, by the way, the AAA drafted baseball rules. You really want to roll the dice? Go with baseball arbitration. It's an all or nothing, right? Most people do not want that at the end of the day, right? They actually want, and they hire us as arbitrators to really delve into the facts, the details, and to give a reasoned award, right? Which is, as Roger said, typically not an all or nothing proposition, particularly when you're dealing with multiple claims. Some of them are, of course, unpaid invoices that the defendant has no excuse for not paying. But then you've got maybe a massive lost productivity claim or a total cost claim that you're dealing with. Yeah, and then we as the arbitrators have to figure that out. We don't always get the tools we need to do that, by the way. Parties don't give us what we need to really figure that out, or they assume we're mathematicians or quantification experts that are going to somehow magically figure it out for them. A practice pointer is if you don't want a bad result, give your arbitrators the tools they need to find in your favor, and including but not limited to the various scenarios where they might find in your favor on one thing but not the other claim, etc. So give them the tools they need in order to figure that out in a reasoned way. Often the parties skip over that, or they just assume, well, I'm right, I should get paid all of it, and they have no fallback or other options for the arbitrators to give them.
Ultimately, a lot of this goes back to burden of proof, which is a concept that I think needs to be emphasized more with parties, because just because you're in somewhat of a less formal setting and you don't really have an appeals process doesn't mean that the party who's asserting a claim doesn't have to meet its burden of proof. The case I just arbitrated for a month had 600 separate change events, and one expert just came in and said, well, I reviewed all these change events and here are the ones that I think are attributable to the other side. And the other side's expert got him and said, well, I've gone through about half of them and based on extrapolating from that, here's how many I think are due to the other side. And then so I asked, well, I said, did you guys have your depositions taken so that each side could evaluate these lists that you prepared? And the answer was no, they decided not to have expert depositions. And although as I've indicated earlier, I'm a critic of experts overreaching and taking on tasks that really don't involve expertise. One thing I think that experts can do very effectively and ought to do is, if you have very complex cases with huge numbers of issues, they need to find a way to summarize those issues and then to respond to the other side's similar summary. So you end up having a meeting of the minds on the exchange of information. Because without that, as Wendy said, how is the arbitrator really supposed to navigate through that? And the results tend to be sort of patchy, and then people call that splitting the baby. There's also a perception by people, just to get the deal with the gorilla in the room, there's a perception that arbitrators, because they are retained by private parties, have an interest in trying to avoid slamming one side too hard because they're worried about getting future business. For one thing, if you pick an arbitrator who's pretty busy, they are really not going to be influenced by that because they have plenty of business to keep them busy, maybe too much. Secondly, if you're worried about that factor, then pick an arbitrator from outside your local state or your local community, somebody that's not going to be getting future business from the parties in where you are practicing, where you are litigating. Because then nobody can really blame, nobody can form this argument about splitting the baby to generate business, because somebody's never going to be back there probably. So there are ways of dealing with it if you really perceive it's a big issue. And but remember the burden of proof issue, without which you're never going to have the big home run unless you play by the baseball rules.
Yeah, so I'll jump in. I too, like Roger, I agree with everything everybody just said. Like Roger, I don't feel that I've ever split the baby, but I do think that one of my old sayings about when I myself, was trying a lot of cases as a litigator is, you lose objectivity at the end. You go into a case and you're in love with that case and you're going to fight it until you are done fighting it. And so you may think that you're entitled to win everything, but just as everybody else has said, there may be 7 million of provable damages out of the 20. And that's something that is very hard to understand when you're in the advocacy position. When Wendy was talking, I was thinking exactly along the lines of Doug with burden of proof. And that's a very important practice pointer, because most of us are pretty good mathematicians, all right? Most of us do understand construction damages, and we're able to look at backup if it's given to us and understand how to make a decision if 100% of the claim is not appropriate. But so many parties don't give you what you need. They really don't give the tools. And I think that it would be helpful, just as you do with a jury consultant, where you're thinking about how is this jury thinking? You need to get into the minds of the arbitrators and say, okay, if I was sitting and hearing this case, what would I need to know? And you know which are the close issues and which are not the close issues. But, I had a case recently where the winner of an issue would be clear, but the amount may not be so clear. But the opposing party didn't give the information that would be needed to make a decision about what a different alternative award would be. And that leaves us, you leave your arbitrator in an all or nothing situation. That's not really where you need them to be. And I don't think that's splitting the baby. I think that's making a fair decision.
I think most arbitrators work very hard to get it right. And they try with all their ability to get it right. And the concept of splitting the baby really doesn't come up in the deliberations when you're sitting there and working with other arbitrators. Folks that have never been in that room may think that, but that's not what happens. Second thing I wanted, just for learning point, I think the AAA did a study on this that they finalized 2 to 3 years ago. I don't have it off the top of my head, but that, empirically disproved this idea that arbitrators split the baby. And they went through and analyzed several thousand awards and, as a database for their conclusions. But I'm sure it's still out there on the AAA's website. If anybody's interested in that issue, can go and pull it down there.
Okay. We've got one audience question, and that is, are there any practical recommendations for attorneys representing parties in a hybrid mediation arbitration process?
If a hybrid mediation arbitration process means that you're mediating to the point of impasse and letting the arbitrator then make the mediator now become an arbitrator and make a binding decision, I think there are a lot of practical pointers for that scenario, because I think it changes the way in which you mediate. I don't personally like MEDAR for that reason, because I think that if you want to give your case the best chance of settling, you want to, get naked in the bed of truth, so to speak, and tell the mediator everything you need that mediator to know. And having done that, it's hard to unring that bell, I think, if you then entrust that person to make a final binding decision. So I guess my practical pointer would be question whether you want it to be the same person. But if you have that in an agreement, then you need to approach the mediation more like an advocacy session. And yes, do make an effort to settle, but remember what tools you have available. I think a lot of times in mediation, I feel like people think they're in jail, like they're stuck in separate rooms and they can't actually communicate with the other side. And you may want to consider, freeing yourself from the construct of being stuck only communicating through the mediator, and actually communicate with your opposing party to try to see where you can get at the end before you toss it to a binding decision.
I've had two situations, sort of the opposite, where I was the sole arbitrator and the parties asked me to become the mediator after 2 days of hearings. And I thought that was a very awkward situation to be in. And so I said, are you sure you want to do this? Because if this mediation fails, I'm still going to have to render an award here, in this case as an arbitrator. And they both signed off on it. And I guess I was lucky. I got them both settled through the mediation process, but it was highly unusual.
I've had the other thing happen, Roger, where I served as a mediator on 2 different cases where, 6 months or a year later, after the cases didn't settle, they came and asked me to be one of the 3 arbitrators on the case.
I had that too.
And you go through that whole, you got to go through a pretty rigorous acceptance process by them, but it's a strange dynamic for sure.
Right.
Yeah, I would never, as a party, I would never enter a process knowingly saying that we're setting up the mediator to be the arbitrator as well. Right. Because it would totally change the dynamic about what you would feel safe in telling the mediator during the mediation phase. Now, it's normal, it's very commonly happens that when parties achieve a settlement in mediation, they will specify that the mediator will become the arbitrator if there is a future issue in implementing the settlement. And I think that makes sense. Right. But to have the arbitrator, take over, I'll just tell you one short, which I consider sort of a funny story. Years ago, I had a case where parties tried 3 times to mediate, same mediator, and it didn't work. And at the end, and I was representing one of the parties. I wasn't serving as a neutral. And at the end of the time, the mediator came forward and offered his services and said, well, I could be the arbitrator. And he said, I think you guys have a really strong case. So my client said, well, you just heard this guy says he thinks we have a strong case, so, you know, maybe you should do it. And I actually was cautious because I said, you know, this guy's we've already paid him 3 times to be a mediator, and do we want to pay him a 4th time? But the client said, no, let's do this because it's going to be faster. So we then go into arbitration. At the end of the arbitration, after both sides have collectively put in all the experts on the West Coast, basically, in this one very technical issue, the arbitrator goes away to like rugby matches or something in Great Britain. And months later, finally issues a decision, which is like 3 sentences long. And it says, I'm rejecting, each side had a claim for like, I don't know, $1 million against the other. And he says, I'm rejecting all the claims by all parties because I didn't feel that I ever really got to hear from any genuine expert. And which was not true. And he obviously couldn't remember the case. And he said that was it. So the lawyers for the 2 parties got together afterwards and talked about it. And so I asked the lawyer on the other side, I said, well, when he volunteered as an arbitrator, what did he tell you? He said, oh, he told us that we had a really strong case. And so that to me really is kind of the crossing the line self-promotion aspect, and which would never happen with the people that I'm honored to share the panel with today. But there are people like that out there. So I would be cautious about Mead Arb.
I want to try a couple lightning round questions real quick, hoping to get 1-word answers from our panelists. What is the most obscure location you've ever conducted an arbitration? Give everyone a moment to think, and we'll go clockwise on my screen, which means Albie, you're up first.
A residential house that was the subject of the arbitration.
All right, Doug.
An island in the Aleutian chain in Alaska.
Wendy.
Is it wrong to say the Waldorf Astoria in Manhattan?
Well, that counts. Roger.
You're looking at it virtual in my office, looking out at the golf course that's about ready to get destroyed by a Category 3.
Jenny.
Bermuda.
All right. Next lightning round question, hopefully can be answered in a yes or no, but if it's a yes, maybe feel free to elaborate. Have you ever had to kick a fellow arbitrator under the table? We'll go in the same order. Albie.
Yes.
No.
Yes.
No, but I had a situation where one of our chair, in fact, I believed had early onset Alzheimer's, and it eventually turned out to be the case. And so I had to report him to the AAA, unfortunately.
No.
All right. Have you ever had to yell at one of the lawyers appearing before you? Albie,
Not yell. Not yell. Speak
Close.
strongly, perhaps, but not yell.
Doug.
I have raised my voice in reminding people that certain issues have already been ruled upon and therefore don't need to be raised again.
Not yell, but strong voice.
Not yell and a stronger voice.
In a mediation, not yell, but use some swear words.
And then I think we have most of the panelists' opinions on this topic, but chess clock, yes or no?
Strongly, yes.
Yes.
Strongly, yes.
Definitely, yes.
Agree.
All right.
And often you don't need it. You know, often you have enough time and it never all gets used, but it's such a great tool if you need it.
I had a case where people were running out of time and it really affected their presentation at the very end of the hearings.
Okay. And then do you prefer witness statements or live direct testimony?
It depends.
Doug?
For experts, sometimes. For fact witnesses, no.
It depends, but I personally like witness statements a lot.
Yeah, I'm with Wendy. It depends, but I like them a lot.
Saying it depends, but I like live testimony.
Well, I appreciate you all playing along with my little lightning round question. Took a little diversion there.
Todd, I was going to say, Todd, I think this actually segues nicely into the question we got on the screen just now is what matters more, testimony at the hearing or the documents? That's a great issue for debate that I think a lot of people have varying views on. Certainly the documentary record is contemporaneous and quite compelling, but we've all seen situations where and cross-examination, you get a lot of other information comes out about context and whatnot that can actually turn the issue in the opposite direction. So it's a depends question, but it's certainly a great topic for debate.
Wendy, you're reminding me of something that I was thinking about when you and Doug were talking about burden of proof and giving the arbitrator the tools. And this is a true practice pointer. In every one of these cases, we've got the thumb drive or the cloud with documents all over the place, a huge, huge evidentiary record, but the people end up using a fraction of that in the hearing. Please don't expect that the arbitrators can go back and make sense out of everything that's in the record. Some things, maybe if there's supporting documentation or cost reports or things that are important to the claims that can't be discussed in testimony. But as a general proposition, if you've got smoking guns, get them out there. Don't leave them in the cloud.
All right. And one last question I'll end with relates to expert witnesses. I've got two maybe jumping off points. One is any thoughts on hot tubbing of expert witnesses, as it's often referred to? And then the other question is, do you like to see a kind of standard question and answer session with an expert, or do you like to let the attorney kind of queue up the expert with some preliminary questions and then, so to speak, turn the expert loose to give a presentation? Wendy, do you want to start?
Sure. I like the format where I do like hot tubbing if they're truly like for like. I mean, they need to be matching experts for hot tubbing to work effectively. But I do like for the experts to make a roughly 1 hour presentation overview, usually with a PowerPoint presentation, which summarizes their opinions for the tribunal. I find that to be extremely helpful. And oftentimes, at that point, they've had more time to consider each other's reports and opinions and might be able to narrow the issues. I even invite experts to confer. I like after they submit their initial expert reports for the experts to confer, particularly cost experts who seem better equipped than most at doing this. They get together and they identify where do they actually depart on the issues. It really streamlines things when they do that. And so I encourage that as well.
It can be effective. It's used more, I think, in international arbitration than it is in domestic, because in the United States, we still have a lot of these kind of old time claims experts who purport to be experts in everything and who are there as advocates really more than as experts. And those people don't accomplish a whole lot in hot tubbing situation because they're just trying to browbeat the expert on the other side. But if you have legitimate, independent, technically minded experts who have pride in the sort of authenticity and credibility of their work, then it's fine to let them confer with each other and see what they come up with. But I'm also a big fan of requiring rebuttal statements to expert reports so that the parties focus on, and give the experts a chance to respond to each other's points before the hearing, as opposed to having a bunch of surprises come out in the middle of the hearing as to how one expert answers the arguments of another.
So I like Wendy's preference, which is have them do a PowerPoint presentation, and then the panel, typically on the panels that I've been involved with, would get together and determine whether or not it would be worthwhile to hot tub. So many times on schedule and delay issues, with the same set of facts, the experts come up with completely different answers, and the hot topping process is, in some of those cases, is totally useless. And so we, as panelists, have to try and dig through the muck and figure out what we believe to be the true facts and delays on the project.
In the right case, joint expert report, so hot topping and then a joint report submitted on areas where they agree and disagree can be extraordinarily valuable, but it's a decision I think you need to make on a case-by-case kind of basis.
Exactly.
Absolutely, it depends. I do have in my standard preliminary scheduling order that the parties are encouraged to have their experts confer and provide joint opinions to the extent that those exist. I've seen that happen really a fraction of the time. Most often people want to come in and give their presentations, and I think the presentations are generally helpful.
Yep.
All right. Well, we have reached the end of our time. I can't thank you all enough for sharing your wisdom with us. The Georgia Construction Bar just got that much better, having learned everything we just did. So on behalf of everyone who's all stuck on mute and not allowed to say their thanks, I'll say thanks again.
Thank you.
Thanks,
Thank
everyone.
you.
Bye-bye.
This concludes today's meeting. Thank you for joining and have a great afternoon.